So the meta story here is this: Giorgio had some pain in his left lower wisdom tooth, right? And he was getting some food stuck in there as well. And I think it was beginning to abscess a bit. So he went to see his general dentist, and his general dentist does an examination. And like a lot of general dentists, wanted to refer him out to an oral surgeon for this extraction, likely because sometimes these things are impacted, they're close to nerves, and it's can be a little dicey. So he refers him out to the defendant in this case, a Dr. Jeffrey Osguthorpe. And when he sees Dr. Osguthorpe for the first time, Dr. Osguthorpe does an examination of him, and then he takes a panoramic x-ray, or Panorex, I should say. And that's where it shows the full mouth, all of the teeth. And he takes Giorgio into a room and he puts the Panorex up on a screen and he says, you know, I see something, but I'm not really sure what it is. And he goes to Giorgio, he says, do you see it? And Giorgio says, no, I really just see black and white and bone. He says, it looks to be a dark spot. So he says to Giorgio, he says, what I'd like to do, Giorgio, is I'd like to take out that left tooth, that wisdom tooth, and then I'd like to take a small sample, do a biopsy, take a small sample, send it out to the lab, bring it back, let's see what it is and what we need to do at the, for next steps. And Giorgio says, all right, and he leaves the office. In the meantime, the doctor has him go get a CAT scan. He orders a CAT scan before he leaves. And the doctor gets the CAT scan before Giorgio comes back for the next appointment. And the report is very interesting because what it says is that the image is suboptimal, meaning I got a bad image here. And it also says due to lack of IV contrast. In other words, what he's saying to the doctor, John, is not only did you order the wrong test, but it's a bad image. And he says, what I would recommend is you get an MRI with IV contrast. Well, Dr. Osguthorpe doesn't take the recommendation of the radiologist. And when Giorgio comes back to his office for the extraction, he takes that tooth out and schedules him for the biopsy 3 days later. And when Giorgio gets to this biopsy, there's like confusion right off of the bat. He walks up to the receptionist, John, and he says to her, I'm here for a biopsy. And this receptionist hands him this form that has him take, with the doctor saying, basically, we're taking all 4 teeth out and we're going to take this entire mass out. He says to the lady, he says, look, I'm not here for that. I just had my wisdom tooth taken out. I'm only here to get a sample. And so she quickly changes, goes back, runs around, scrambling around, trying to figure it out, comes back and says, we charged you for the wrong thing. They recharge his credit card. He sits down and he's real nervous at this point. And so nurse comes back, a surgical tech takes him back in the back room and has him fill out a form. These are called consent forms, John. And the consent form says they're going to do an incision and biopsy, which is taking that small sample. And when the procedure starts, the doctor changes the report, the surgical report, to say excision and biopsy. So the patient's told, I'm going to take out a small sample. And now the doctor's saying, I'm going to go get the whole thing. And so he starts the procedure. And one of the first things, John, that doctors have to do, oral surgeons, when they're doing a biopsy, is they have to put a needle, right, and syringe into the site to draw fluid, okay? Because if the fluid comes back and it's like chalky or white, then they know it's a cyst, right? If the fluid comes back and it's red, they know it's vascular and they got to stop. But he doesn't do that. What he does is he drills into this thing, and I'm going to show you what he drills into. Sorry. This here. This is an arteriovenous malformation, also known as a vascular malformation. And the way that I explained this to the jury is like, this is like a high flow blood tornado between arteries and veins should never connect through these vessels.
And is that normal, Vince? Is that
no, that's not normal. It's not normal, but it's something that all oral surgeons have to look out for, because if they do what this doctor did, which is to drill into it, not knowing what it is, what do you think happens?
Boom.
Right, exactly. So what happened in this case was he drills into it in his office and causes a massive hemorrhage in my client's mouth. He can't stop the bleeding. They've got to call paramedics who take him across the street to the hospital. They have to intubate him, do a blood transfusion, and then they tell the wife, hey, look, we can't stop the blood here. Now he's got to be airlifted to our level 1 trauma center where he's then has to undergo an emergency surgery to save his life. And when he wakes up, he's got numbness in his left jaw, no feeling on the inside of his gums and cheek. And he's got massive post-traumatic stress disorder because he's now got this preoccupation with death. And essentially that was the case.
So guy goes in for a somewhat routine procedure, and then disaster strikes.
Right.
And Vince, before we get into about the facts, I always think it's very important. We're not insurance adjusters. We don't treat our clients like pieces of paper, or like a commodity. And tell us how your client presented as a human being, and maybe tell us how the defendant doctor presented just as a person. Because I got to tell you, when I walked in, I'll tell you my perspective, Vince. When I walked in and saw your opening and saw voir dire, the defendant doctor looked to me like a little shady. He had on like kind of an ill-fitting black suit. He just looked a little rough. And I thought your client looked just like a great guy. I don't know how else to say it. Now, did you have to work with him on that, or tell us a little bit about the human being that was involved here?
Well, you mentioned the defendant doctor, so I'm going to bring him up so everyone can see what he looks like. This is him. All right. And what's interesting about this doctor is that he wasn't even working for this clinic at the time we tried this case. He had left this clinic a couple of years earlier, and he left it to do what? To go part-time in Utah so he could ski recreationally, right? So, this is a guy that was just, he was just not committed, right? He wasn't committed to his craft. And I tried to get that across. I think I got that across to these jurors. Now my client, okay, I will tell you, I had worked with him 6 different sessions to prepare him for his examination. I have never worked with a client that many times to get him ready because he could not get out of his own head. I knew him as a person, and his personality was amazing. But because he's smart and because he was trying to answer the question in such a way that he would be giving the right or the best answers, he just couldn't connect. And so finally, what I did with him on the very last time that I was with him, John, I said, look, because I tried everything. I didn't even know what to do with them anymore because, for example, when he came in one of my sessions, he dropped 177 questions on me and he says, this is what I think you should ask of me. And so I looked at it and I set it aside. I said, with all due respect, we're not going to do that. Okay. We're not doing that. And so I said to him, I said, Giorgio, what I'd like you to do when I ask you questions, I would like you to explain to me the different scenes, right? The different events that took place, like you were telling your 4-year-old child or your 5-year-old child. And somehow in his brain that clicked. And when he took the stand that day, which would, after 6 prep sessions where he absolutely was not getting it, he gave the best direct examination I've ever done or seen in my entire career.
Did he cry? I mean, was he emotional or?
He did. He cried. And it wasn't contrived. It wasn't, it was real. And in fact, I had more questions of him when he did get to that point where he couldn't hold back the tears any longer. And I knew that I wanted to get to those questions, but my instincts told me, don't ask anything more. Just let it resonate. Let it sit there in the space right now. And when I did that, the defense lawyer stood up to cross-examine him, and he was completely lost. he was completely taken off guard because he didn't know how to deal with the emotion of the event.
And we talked about that yesterday in my case as one of the most challenging things, Vince, is not filling space, is to allow sometimes things to hang or sit there or sink in. One of the greatest dramatic techniques is silence and at the appropriate time and letting things set. And it's also one of the hardest things to do because we want to fill space.
Right, exactly. So I think we have a natural impulse because we don't want to be rude, right? We don't want to feel uncomfortable. And so when a conversation gets to a point where there's this awkward silence, what we naturally want to do is we want to jump in and fill that void. And you're right, in a courtroom, when you've got a question maybe that's hanging out there, especially on cross-examination, and they don't want to answer it or they're thinking about it, and you want to kind of jump in and sort of kind of push it along,
right?
That's when you got to be very disciplined. And you know what? We'll talk more about this in voir dire because this is what happened to me on voir dire. Even though I believe I picked a pretty good jury, I know that there were some things that I could have done better. And one of those things was that when I asked questions, great questions that Dan and me worked on for a long time, since 2017 probably, but I didn't let the jurors, and you saw this because you commented to me about it, I didn't let the jurors answer those questions when there was that awkward silence, and I would immediately go to the next thing. And so I think in retrospect, I would do that different.
Vince, before we get to your voir dire, can you tell us, I mean, did they offer any money in this case? And we should let our listeners know in Michigan, we do have caps on medical malpractice damages, which affect how we have to evaluate our medical malpractice cases, and they affect the types of demands that we can make. So Vince, what's the caps now? You would know this better than I do because I don't do a lot of med mal.
Sure. So in Michigan, the low cap, right, because this is not a case involving a reproductive organ or one of the other factors, this is a $497,000 low cap. And
that only applies to non-economics, right?
Non-economics, that's correct, right. So in this case, this doctor, and this is not unusual for oral surgeons, I've learned through the course of this case, is that in this case, this doctor had a provision in his policy that allowed him to withhold consent from his insurance company. And his insurance company never had the opportunity to try to negotiate a resolution of this case because he never let them off of the starting line, not once. And in fact, John, our judge, who was the chief judge of Macomb County, because the doctor had moved to Utah, ordered him in 3 times to settlement conferences and 1 trial date. This case was up for trial on 3 different occasions, but he ordered him in and made him fly in on his own dime. And he was still obstinate. He was still stubborn and arrogant. And his lawyer's hands were tied, and his insurance company never got to evaluate the case.
Why would a doctor like this not want to give consent and have this be done and not have to go to trial against the famous Vince Colella?
Well, first of all, I wasn't famous in the area of dental malpractice, that's for sure. If it was a civil rights case, maybe. But no, the truth of the matter is that what I was told, and I learned this along the way, because I kept asking myself that question, right? I was like, who cares? You got insurance. This isn't your money. There's $1 million in coverage here. What are you doing? The answer is because this doctor was afraid that he'd have to report it to the licensing bureau. And here's what's so silly about this man. The reporting requirements only mandate that if a settlement is over $200,000, it has to be reported. This case evaluated for $199,000. And for those of you who don't practice in Michigan, all cases in circuit court that are filed asking for money damages have to go before a 3-lawyer panel, 1 lawyer who's a plaintiff's expert, 1 who's a defense expert, and 1 who's supposed to be neutral, but usually they're not. But this panel then decides what the fair value of the case is. And they decided that this case, the fair value would be $199,000. And in Michigan, if you reject that number, you got to do 10% better at trial, or you have to pay the other side's attorney fees and interest. Now, we accepted that number. They rejected it, which puts sanctions in play now for post-verdict motions.
Wow, that's crazy. Vince, someone's asked, who is the insurance company, by the way?
OMS is the
Okay.
name of the insurance company.
And
And they really, and that company is one of the insurance companies that insures most general practice dentists and oral surgeons.
so so you accepted this 199 case eval, which obviously happens after all discovery is closed and everything.
Right.
But was there any other settlement negotiations? Was there any offers prior to trial? Tell us about those. And what was your final demand before going to trial?
Well, there were no other offers. Again, he never got out of the starting blocks. I had already accepted $199,000. And I want to talk about that for a moment too. It's not that I thought the case was worth $199,000, right? But I had a client who works for a environmental waste management company. He's an account representative. He's got a wife who works as a social worker. They have an income. What I didn't want to see was something go sideways at trial, and now they're looking at potentially sanctions and paying this attorney, the defense attorney team for this trial. And so even though I left it to their discretion, I sort of suggested to them, look, if they're not going to make an offer and they've already signaled that to us, then let's go in and try this thing risk-free. By risk-free, I mean to you, not to me, because I'm spending all my time and my money, but risk-free to them, right? This couple who had a child on the way, and at that time, another child on the way, I didn't want to see them be put at any type of risk. So we got to try this case for them with no risk at all.
And those are sometimes the best situations, right? It's the hard things, the hard times are when there's a substantial amount of money on the table and you have to look your client in the eye and tell them, I know this money can change your life, but I'm advising you not to take it, and then putting everything on the line. When the defense doesn't offer any money, it makes our jobs easier in a way. No offer. Like on my case yesterday, no offer. All right, we only have one thing to do. That's boot up and go to battle. So,
right. But of course, the issue with that is always that I think that this happens way too often. I think that us plaintiff lawyers, we get ballied into trying our bad cases, right? We don't really try our good cases because the insurance company recognizes there's such a risk. They end up coming up with a sum of money that makes it very uncomfortable for our clients.
right.
And quite frankly, it's the smart play a lot of times to just simply settle the case, right? Because we've gotten burned in other cases as well, even what we thought to be a very good case.
That's right. Yeah. There's a saying. I talked to an insurance company adjuster once, and he was telling about adjusting a lot of these cases. And he says most plaintiffs' attorneys, once you get to 2 or 3 million on the table, he's like 3 million is the soft spot. Almost everybody takes it because
Right.
it's a hard amount to turn down. But
Right.
in any event, Vince, so was there any offer prior to trial? And what was your final demand prior to trial? Did you even make one? Did you make?
I didn't. I considered the 199 to be my final demand because that was the ceiling that I created with the acceptance of that case evaluation number. So with that being, the number, I knew that there was no point in, at any point saying, okay, I want more than that. He was just never going to concede. He made it very clear to us he was not going to ever offer a single penny on this case.
Okay. So tell us about, Vince, kind of leading up to the trial. Did you do any focus groups or any other type of pre-trial, mock trials, anything of that nature?
No, I did. No, I didn't focus group this, but to be honest, I have two very good friends. One is a general dentist and one is a prosthodontist who does jaw reconstructive surgery. And I had spoke to them very early on when I got this case. And listen, folks, if you're doing med mal and you have to learn the medicine, it's one thing to be reading these journals and whatnot. It's another thing to be able to sit down, if it's not with a doctor that but with an expert, and really get the medicine down, because that was my biggest concern. I knew that I was going to have to battle these doctors, the defendant, his expert on the medicine, And you got to be very careful because they have such a wealth of information that you don't want to go down the path of looking like you don't know what you're talking about. So when I had spoken with these two dentists, this surgeon and this general dentist, they had from the start told me what this doctor did wrong. And I always knew that he had committed malpractice. And the reason that's important was because when this case was about to go to closing, they had finished with the defendant himself and their expert. Those are the last two witnesses that this jury saw. And I felt like I had a ton of steam, a ton of momentum getting into that point. And maybe through those two witnesses, although I think I did an effective cross, they heard a lot of things from two people that were, quote, experts, right? That may have cast some doubt on our claim. And then I started thinking to myself, maybe I'm going to be asking too much. And I was sitting outside. I'll never forget this. I'm sitting in the pews outside of the courthouse, in the courtroom, outside the courtroom rather. And I'm thinking to myself, you know what? Maybe I should just lower my ask here. And then I hearkened back to the conversations I had with these two doctors, my two buddies, who told me all along that this was a medical malpractice case, and it completely changed my confidence. And I was like, you know what? I'm right. They're wrong. I'm not going to go in there with my tail between my legs. I'm going to let it all hang out in closing because this is the righteous place to be. And then, of course, it turned out.
So what about, what worried you going into this case, Vince? Like, what were challenges when you're getting ready for your voir dire and your opening and you're evaluating this case and you're talking to your client? What really concerned you, or what did you think, wow, this is a big problem that I'm really concerned about?
I wouldn't say that there was one big problem. Like, for example, it's not like, I had a client that had a felony that was going to come in, or had 4 prior claims, or, or potentially had done something wrong where they were going to get hit with comparative. My client was sedated. He went into a trusted relationship with a doctor. He relied on what the doctor told him, and he was out when this doctor injured him. What could he have possibly done wrong? But I had the general concerns that all PI lawyers do, right? We just come out of COVID. I don't know how jurors are going to feel about healthcare workers because, quite frankly, we all know that they were heralded for a couple of years for all of the work, time, sacrifice, and effort that they put in. I was worried about the fact that we've got this reputation as these greedy trial lawyers who are only looking for money. And then I had the one concern about his injury. Because although this was an AVM, of this vascular malformation that got pinched during this procedure, I was concerned that there was no testimony or evidence about actual nerve damage, other than some references they were references by the expert and in the records, but it wasn't something that was glowing, wasn't, glaring out to me. So those were really my only concerns. But, the way that I kind of approached this was, if I can get jurors with an open mind to hear this case in its entirety, they are not going to like this doctor. So really what I was looking for were jurors that were going to gravitate towards us, not immediately shut me out, not immediately shut their ears to this plaintiff lawyer and what he's saying, that are going to hear all the evidence and that are going to disqualify themselves to cause challenges if they felt they couldn't serve. And so that's how I kind of constructed the voir dire. So
take us through your voir dire. What happened? How did it go?
Well, I thought, well, like we said earlier, this was a great jury. Like, we ended up with the right jury, obviously. But there were times when I was questioning them about things and they just weren't chiming in. I've had jurors, John, where they're like having discussions with themselves and I'm learning information.
And you're like, yes,
let's talk about this shit, right? Like, so, but they weren't like that. However, in thinking about this for today's, presentation, the one thing I did notice about them, they were always very attentive to what I was doing and what I was saying. Because we all know that, like, when you're standing there and you're talking, you could see people roll their eyes.
Right.
you know, they look down, and because they're just something about, they're just not hearing you, or they're not comfortable with you. I didn't feel that really at all. And the two challenges, the peremptories that I used, you know, they were borderline cases. I mean, they may have been able to serve on this jury.
Well, tell us about, how did you structure your voir dire, and would
Sure.
you, what
Sure.
type of questions did you ask?
So, okay. So this goes back to 2017. So when I first started working with Dan, and at the time Trojan Horse, now Trial Lawyers University, Dan provided us with these juror scripts, right? These scripts for talking to juries. Now, I don't call them scripts anymore. I just call them juror dialogue. And one of the, of course, the starting space was brutal honesty. And I talked to them about this concept of brutal honesty. And I asked them, what does it mean to them? And they were very forthcoming. They would say, oh, you know, it's like not having a filter, or it's, you know, saying what's on your mind. And when they would say their responses, I would parrot them back to them, right? To see, you know, to reinforce, like, this is what we're talking about. And then I gave them the example of the ugly sweater, right? It's like, you know, you're at Christmas and you get a gift, and it's like, you open it up and it's like this reindeer with bells on it and shit, like, and you're looking at it and they say, hey, you know, how do you like it? And you're like, oh, this is great. Yeah, I can't wait to wear it, you know? So, and they all kind of understood that. And then from there, I moved into the bias and prejudice. And what I did with that was I basically said to them, look, there are some cases as a lawyer that I won't take, right? Because of my beliefs, my experiences. I can't take those kind of cases. I didn't give any examples, but I just said that. And then I used the judge. I said, and there are some cases that this judge, if he were on the bench, he'd have to recuse himself, because if he searched his conscience, he would know that he can't serve. And then I gave him the example of a BP oil spill. I said, look, if we were here and we were trying the BP oil spill, and I had the CEO that's sitting right there where you are, juror number 3. And I asked them, you know, hey, you know, this is a case about your company. Do you think you could be fair? And he says to me, yeah, I think I can be fair. I said, who here would believe him? You, juror number 2, you, juror number 5. And they're all like, no, 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 no. So, but that's an extreme example, right? Of course, we all know that. So then I came back to the pie eating contest that Dan always talks about, right? Because now we're not talking, we're talking before about like this extreme example. Now I want to talk about an example where, like, obviously you cannot serve if, you know, you say to the jury, look, if we're here for a pie baking contest and I bake this cherry pie, and one of the other contestants bakes a peach pie and one bakes an apple pie, and you're sitting there, juror number 3, and you're allergic to cherries. You just can't, when you put a cherry in your mouth, you want to gag. Do you think that you'd be the right juror or judge for this contest? They said, no. Does everyone understand? Does anyone think that they can? So now they start getting the idea, like, okay, it's okay, because it's not even just that I have an opinion or I have a financial interest. It's like, there's something in me that I just can't do it, right?
Yeah, Vince, I think that's so important, is setting up a situation where not only is it okay to be honest, is it okay to say, maybe I have certain biases, but it's like almost that's what they're supposed to do and encouraged to do. Because we've been in so many situations where people say, I can't, you know, this bothers me about this case or this, and you have the judge come down on them like, oh, but this is a court of law. I'm going to read you this rule. If I read you the law, are you saying that you're not going to follow the law? You know, and it's like, whoa, like, of course I got to follow the law, but it's so important to set up a situation before we even start the voir dire that makes it okay and encourages. And were you able to do that?
Yeah, and you know what? It reminds me of an example. So I was trying a case in federal court against the Target Corporation, Target. And one of the jurors was soliciting Target for corporate business, right?